Washington, D.C. has one of the most tenant-protective breaking lease frameworks in the entire country, shaped by the district's comprehensive Rental Housing Act, its strong tenant rights culture, and an enforcement environment that actively protects tenants who need to leave a lease early. If you're a landlord or tenant in D.C., understanding the breaking lease rules is critical because the district's approach heavily favors tenants and imposes significant obligations on landlords. Let's start with the landlord's duty to mitigate damages. D.C. law requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. The landlord cannot simply leave the unit empty and collect the remaining rent from the departing tenant. This mitigation duty is well established in D.C. through both statutory provisions and case law, and D.C. courts take it seriously. The landlord must advertise the unit, show it to prospective tenants, and accept a qualified replacement tenant. If the landlord fails to make reasonable efforts, the departing tenant's liability for remaining rent can be substantially reduced or eliminated. In D.C.'s strong rental market, where demand consistently exceeds supply, landlords can typically re-rent quickly, which limits the departing tenant's financial exposure in most cases. The departing tenant's liability is generally limited to rent during the period the unit remains vacant despite the landlord's reasonable re-rental efforts, plus any reasonable costs incurred in preparing and marketing the unit. Given D.C.'s persistently tight rental market, many broken lease situations result in minimal financial exposure for the departing tenant, particularly for units in desirable neighborhoods. Early termination fees in D.C. must be reasonable. The district's overall consumer protection framework, including the Consumer Protection Procedures Act, provides a basis for challenging fees that are disproportionate to the landlord's actual damages. A fee of 1 or 2 months' rent is generally considered reasonable. A fee that effectively penalizes the tenant beyond the landlord's actual losses can be challenged as an unfair trade practice. D.C.'s rent control system adds another layer of complexity to breaking lease situations. A significant portion of D.C.'s rental housing stock is subject to rent control under the Rental Housing Act of 1985. For rent-controlled units, the landlord's ability to increase rent when re-renting to a new tenant may be limited. The rent control provisions generally cap how much the rent can increase even between tenants, though vacancy increases may be permitted under certain circumstances. Landlords of rent-controlled units should understand how the rent control provisions interact with re-rental after a broken lease. Military members have the right to break a lease under the Federal Service Members' Civil Relief Act. Given D.C.'s proximity to the Pentagon, Joint Base Anacostia Bolling, Fort Belvoir, Joint Base Andrews, and numerous other military installations, SCRA-protected lease terminations are extremely common. Active duty service members with qualifying orders can terminate by providing written notice and a copy of the orders. The lease terminates 30 days after the next rent due date. No early termination fee or penalty applies. D.C.'s military population is enormous. The National Capital Region has one of the highest concentrations of military and defense personnel in the country. Landlords in D.C. should have a well-established SCRA process and should expect military lease breaks as a routine part of operations. Many D.C. tenants are military officers, enlisted personnel, or civilian defense employees on temporary assignments who will terminate when their orders change. Washington, D.C. has enacted strong protections for victims of domestic violence, sexual abuse, and stalking that allow early lease termination. Under D.C.'s protections, a tenant who is a victim of an intrafamily offense, D.C.'s term for domestic violence, sexual assault, or stalking, can terminate the lease by providing written notice and documentation to the landlord. Qualifying documentation can include a copy of a civil protection order, a police report, or a written statement from a qualified professional, such as a domestic violence counselor, healthcare provider, or social worker. The tenant must provide reasonable notice, typically 30 days, before the termination date. When a domestic violence victim terminates under D.C.'s provisions, the tenant is responsible for rent through the termination date, but is not liable for rent for the remainder of the lease term. The landlord cannot charge an early termination fee or penalty. The security deposit must be returned according to DC's standard deposit return rules within 45 days of the tenant vacating. DC's protections for domestic violence victims extend beyond just lease termination. Landlords cannot discriminate against applicants or tenants based on their status as victims of domestic violence. This is a protected category under the DC Human Rights Act. Landlords cannot refuse to rent to someone because they have a history of being a victim, and cannot penalize a tenant for incidents at the property that were caused by the perpetrator rather than the victim. Tenants in DC may break a lease if the landlord fails to maintain habitable conditions. DC's housing code is comprehensive and actively enforced by the Department of Consumer and Regulatory Affairs, now the Department of Buildings. If the landlord fails to address serious habitability violations after receiving proper notice, the tenant has several remedies, including the right to terminate the lease. DC's habitability standards are among the most detailed in the country, and the district has an active code enforcement program. Tenants can file complaints with the Department of Buildings, which can inspect the property and order corrections. If the landlord fails to comply with code enforcement orders and the conditions substantially affect the tenant's health, safety, or ability to use the property, the tenant has strong grounds for lease termination. The tenant should provide written notice identifying the specific habitability issues and allow a reasonable time for the landlord to make repairs. If the landlord fails to act, the tenant can terminate, and the tenant's written notice and documentation of the conditions serve as evidence that the termination was justified. DC also allows tenants to terminate a lease if the landlord engages in illegal conduct, such as shutting off utilities, changing locks without authorization, removing windows or doors, or engaging in harassment intended to force the tenant out. These actions constitute illegal eviction under DC law, and the tenant can terminate the lease and pursue damages against the landlord. One unique aspect of DC's breaking lease framework is the interaction with the district's just cause eviction requirements. DC has some of the strongest tenant protections in the country. Landlords generally cannot terminate a tenancy without just cause, and the eviction process is lengthy and heavily regulated. This tenant protective framework also affects the breaking lease context. Courts and enforcement agencies are sympathetic to tenants who need to leave early for legitimate reasons and are skeptical of landlords who impose harsh penalties. From a practical standpoint, DC has one of the most expensive and competitive rental markets in the country, which generally benefits tenants who break leases because landlords can typically re-rent quickly. The DC rental market is driven by federal government employment, international organizations, lobbying and advocacy groups, law firms, consulting firms, technology companies, and healthcare institutions. Demand is consistently strong, particularly in Northwest DC neighborhoods like Georgetown, DuPont Circle, Adams Morgan, Columbia Heights, and Woodley Park. Capitol Hill, Navy Yard, and the Wharf have seen enormous development and strong demand. When a tenant breaks a lease in a desirable DC neighborhood, the landlord can often re-rent within 2 to 4 weeks, sometimes faster in peak season. The departing tenant's liability may be limited to just a few weeks of vacancy rent. Even in neighborhoods with slightly softer demand, parts of Northeast and Southeast DC, the overall strength of the DC market means re-rental typically happens within a reasonable time frame. The seasonal cycle affects re-rental timing. DC sees the strongest rental demand from April through September, driven by new government hires, congressional staff turnover, summer interns, and the academic calendar at DC's many universities. Winter months see slower activity, and a lease broken in December may result in a longer vacancy than one broken in June. The federal government's hiring and assignment cycles also create predictable lease-breaking patterns. New presidential administrations bring waves of departures and arrivals. Congressional staff turnover after elections creates lease breaks. Military rotations and diplomatic assignments generate regular terminations. Landlords in DC should expect and plan for lease breaks tied to these cycles. One best practice for DC landlords: structure your early termination clause to be reasonable and defensible under DC's Consumer Protection Framework. A 60-day notice period plus a fee of 1 to 2 months' rent is generally appropriate. Avoid larger fees. DC's tenant protective legal environment means that aggressive fee provisions are likely to be challenged and potentially invalidated. Another best practice: begin re-rental efforts immediately when a tenant provides notice of breaking the lease. DC's strong market means you can often minimize vacancy, but you need to act quickly. Document every step: listing dates, advertising channels, showings, and when you accepted a new tenant. Your documentation proves you fulfilled your mitigation duty and establishes the departing tenant's actual liability. A third best practice: for landlords who own rent-controlled units, understand how the rent control provisions affect your ability to set the rent for a replacement tenant after a lease break. Consult the Rental Housing Commission's guidelines on vacancy increases and rent adjustment procedures. Getting the rent wrong on a rent-controlled unit after a broken lease can create compliance issues that far exceed the cost of the vacancy. DC requires landlords to return the security deposit within 45 days of the tenant vacating. The deposit must be held in an interest-bearing escrow account at a DC financial institution. The landlord must provide an itemized statement of any deductions. If the landlord fails to return the deposit within 45 days, the landlord may forfeit the right to retain any portion and may be liable for treble damages. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to Washington, D.C. breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.